this video, I'm going to give you an overview of the European merger regulation and its procedural aspects, as well as some of the substantive rules that apply to mergers. Looking at this historically, the Treaty of Rome, now the Treaty on the Functioning of the European Union, did not really include any rules on merger control, unlike its predecessor, the Treaty of Paris, creating the ECSC community. In the Continental Can judgment in 1973, however, the European Court of Justice confirmed that now Article 102 of the treaty is applicable to mergers, as you can see here in Grant 26. However, this case law allowed for merger control only when in the event of the strengthening of a dominant position through the acquisition of a rival. Thus, the creation of a dominant position was not caught under Article 102 of the treaty. Now, in 1973, immediately after the Continental Can judgment, the European Commission drafted a proposal for a merger control regulation. This was subject to ongoing discussions, but culminated in the adoption of a new merger regulation, a new instrument to control mergers, only by 1989, with what was then Regulation 4064/89. In 2004, the Council adopted a new merger regulation, the regulation that is currently in force, Regulation 139/2004. In this video, we're going to look at the structure of the merger regulation. We're going to start with some of the main concepts. These deal with two distinct issues. The first is jurisdiction. What is a concentration and which concentrations are subject to the jurisdiction of the European Commission, and what is the legal regime of other concentrations not caught by the merger regulation. This involves the concept of concentration, Article 3 of the merger regulation, and the concept of European dimension, covered by Article 1 of the merger regulation. Secondly, we have the prohibition or authorization criteria, and these include the substantive test that we find in Article 2 of the merger regulation. In this video, I'm going to follow this order by looking at each of these issues in turn. So let us consider the universe of possible concentrations. Obviously, the universe of concentrations is larger than that of concentrations of an European dimension. And of those that have an European dimension, the ones that may impede significant competition in the single market is obviously an even narrower group. Now, merger control is typically aimed at these concentrations that may impede effective competition in the single market. Now, concentrations with an European dimension are mostly concentrations that do not give rise to competitive problems, as we will see further on in this video. Just a reminder on what is a concentration, the merger regulation defines concentration as a change of control on a lasting basis that results from a merger or the acquisition of control through any other means by another undertaking or the person controlling another undertaking. And again, this can be done through merger, through acquisition of control meaning here the possibility of exercising a decisive influence on an undertaking, and the creation of a joint venture. Please be reminded, as we saw in the first video, that control may be sole or joint. The merger reg excludes investment shareholdings by credit or financial institutions and insurance companies, as these do not aim to have a significant influence in the conduct of the firm, but are rather taken for investment purposes, that is, typically short-term purposes. Also excluded are cases of liquidation, insolvency, and similar winding up procedures, and these two exceptions are covered by Article 3, paragraph 5 of the merger regulation. So there's a dividing line between what is called the one-stop shop principle in the regulation and the issue of multiple notifications. So mergers with an European dimension are subject to the merger regulation, to the EU merger regulation, and thus have to be cleared by the European Commission. Whereas mergers that do not have an European dimension will be subject to the competence of national competition authorities and thus subject to national legislation. Since any international deal will typically cross borders and involve firms operating in multiple countries, then if we have a transaction involving firms operating in, say, 6 or 7 member states, then if the merger does not have an European dimension, in principle, it would have to be dealt with by national competition authorities. Now, let's look at the main test for what is a concentration with European dimension. First, we have a measure of the absolute size of the transaction. So, the transaction must involve a worldwide aggregate turnover by all undertakings concerned of more than 5,000 million euros. Secondly, in terms of its dimension at EU level, the aggregate EU-wide turnover of each of at least 2 of the undertakings concerned is more than 250 million euros. This gives us an idea that there is an impact cross-border. Finally, we have a negative test, and that is the so-called 2/3 rule. If each of the undertakings concerned achieves more than 2/3 of its aggregate EU-wide turnover within one and the same member state, then we assume that its impact will mainly occur at the level of a single member state, and so the concentration will not have an European dimension and will thus be submitted to notification under domestic merger control rules. So this is the so-called 2/3 rule. In 1997, the Commission introduced a secondary test that also includes the absolute size of the transaction, in this case narrowed to transactions involving worldwide turnover between all the undertakings concerned above 2,500 million euros, so half of the standard of Article 1, Paragraph 2, a measure of cross-border impact where in each of at least 3 member states the combined aggregate turnover of all the undertakings concerned is above 100 million euros. The size of the transaction in each member state, of those member states, the aggregate turnover of each of at least 2 of the undertakings has to be more than 25 million euros. And finally, subject to the same 2/3 rule, if the 2/3 rule applies, then the merger will not have an European dimension. Now, we saw that typically we would have this dividing line between mergers with an European dimension and mergers without such dimension. However, the regulation also includes a number of crossovers or bridges between these 2 lines. So, under Article 9, a merger that has an European dimension may be referred to a national competition authority where it has a specific impact in a market that is of national or infranational scope. But there's also a line on the other side, or a possibility of transfer on the other side. And so mergers without an European dimension may be referred to the Commission by national competition authorities. This is in fact what happened when Facebook acquired WhatsApp. The merger did not have an European dimension to start with, but following the referral by domestic competition authorities, the Commission assumed jurisdiction over this case. Another possible interplay occurs where member states have a relevant national interest to protect, even though the merger is subject to the jurisdiction of the European Union. One such case involved a merger between a Spanish and a Portuguese firm, the Spanish Banco Santander Central Hispano, and the Champalimau Group that controlled 2 banks in Portugal. In this case, the transaction had a European dimension, and so it was subject to the European Commission's jurisdiction under the merger regulation. However, Portugal considered that the transaction involved the national interest and the protection of strategic sectors and blocked the merger using financial laws. Now, under the merger regulation, member states may adopt appropriate measures to protect legitimate interests. They may not, however, prohibit a merger that has been authorized by the Commission. This would challenge the principle of primacy of EU law over national law, and envisaged measures must be adequate and proportional. So the Commission recognizes the compatibility of national measures with the merger regulation, both in terms of recognized legitimate interests that are already recognized by the regulation, such as public security, media plurality, and prudential rules, and other interests depend on whether or not the Commission recognizes them as relevant national interests, but they can never lead to the prohibition of a concentration that has been authorized by the European Commission. And so in this case, Portugal did not have the right to oppose this concentration. Now, one of the key rules of the regulation is the obligation of prior notification of all mergers falling within the scope of the merger reg. Under Article 4, Paragraph 1, firms are obliged to notify before the implementation of the agreement and following its conclusion or the announcement of a public bid. The notification only produces effect following the submission of a complete notification. The transaction has to be suspended and the concentration may only be implemented after notification and authorization. So if the transaction is a concentration and it has a European dimension, it has to be notified to the Commission. Now, the consequences of implementing a concentration before authorization from the Commission, so-called gun jumping, are fines up to 10% of turnover. And in 2018, the Commission imposed a fine on Altis for implementing a merger before the concentration was authorized. And this is just an example of the many cases of gun jumping that may occur. Now, in terms of procedure, we have a two-stage procedure with Phase 1 and Phase 2. Phase 1 serves as a triage phase in the procedure. If the concentration raises serious doubts as to its compatibility with the single market, then the procedure starts with Phase 2. Now, the Commission has a number of investigation powers, such as RFIs or requests for information under Article 11, inspections, Article 13, and it may conduct hearings, Article 18 of the Merger Act. If firms supply incorrect or misleading information, they may be subject to fines of up to 1% of turnover. And they may also be subject to periodic penalty payments that cannot exceed 5% of average daily aggregate turnover. These are meant to be deterrent and ensure cooperation with the Commission's exercise of powers. Now, there are two types of decisions. Phase 1 decisions are grounded on Article 6 of the Merger Reg. Under Article 6, the Commission may decide that the notified merger does not fall within the scope of the merger regulation, and thus there was no need to notify. It may decide that the merger does not raise serious doubts as to its compatibility with the single market. It may also understand that the merger has to be subject to conditions and obligations in order to ensure that it does not raise serious doubts as to its compatibility with the single market. And finally, if the merger raises serious doubts as to its compatibility with the single market, then the Commission opens Phase 2 proceedings. At the end of Phase 2, the Commission may adopt a number of decisions under Article 8, that the concentration is compatible with the single market, that it is compatible but only following modification by the parties, that it is compatible but subject to conditions and obligations to ensure that it does not provoke detrimental effects in the single market, and finally the Commission may prohibit the transaction by deciding that it is incompatible with the single market. The Commission may also adopt a number of conservatory measures in order to preserve the competitive situation or actually to restore it if the merger has been implemented in breach of the suspension obligation or if there's a breach of a condition upon which it had been authorized previously or where it has been declared incompatible with the single market. Now, let's look at some statistics. From a total of, at the end of October 2021, of 8,390 notifications, this corresponds to a number between approximately 361, 414. The highest year was 2018. Again, we can see that merger activity is really impacted by economic activity in general, and in this case there was a decline of mergers, particularly in the year 2020, with a pickup in 2021. The number of prohibition decisions is quite small. It is a total of 30 prohibitions between 1919 and October 2021. That is, of all the phase 2 proceedings, this is 0.1% of all phase 2 proceedings have ended in prohibition, and this amounts to 0.0036% of all notifications. The most likely result, whenever there's a problem in terms of serious doubts as to compatibility, is really to have a decision on remedies, of which, as you can see, there are 336 decisions on remedies, also known as conditions and obligations, in phase 1, and 141 out of a total of 234 decisions in phase 2. So 60% of phase 2 decisions have ended with conditions and obligations. Now, you can also see that in terms of merger prohibitions, there have been 15 mergers prohibited until 2001, and since 2001 there have been another 15 merger prohibition decisions, with 3 merger prohibitions in 2019, which was a new record year since 2001, when 5 prohibition decisions were issued in a single year. So just a brief look at some of the prohibitions in 2019. These 2 prohibitions that you can see in this slide deal with traditional industrial sectors, and the concerns were with unilateral effects, the creation of a dominant player in steel laminated products, in the Wieland or Ruby's rolled products Schwermetall, with both an horizontal and a vertical impact, and the Tata Steel case, ThyssenKrupp joint venture, where the transaction would combine the second and third largest producers of carbon steel flat. But the most controversial prohibition that took place in 2019 was one that dealt with the Siemens Alstom case, again a case of unilateral effects. This transaction would have combined the 2 largest producers of different rail signaling systems, as well as railways rolling stock in Europe. And the reason for the controversy was that the transaction was pushed by the French president and the German chancellor. They pushed hard politically to have the deal approved by the European Commission, with the argument that Europe needed to have this giant cooperation so that it could compete with Chinese train manufacturers in global markets. The Commission's response was that this could not be done, this end of industrial policy could not be done at the expense of European consumers. And this concludes this video, and so thank you for watching, and I hope to discuss this in class with you. Thank you.